Counsel, you will each have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes.
May I
Let's
please?
just wait 1 second.
Sure.
I'm going to let him get ready here.
Thank you.
In case he wants to take notes there.
Thank you.
Thank you. You can proceed. Thank you.
May it please the court, counsel. My name is J.R. Russell, and I'm here proudly representing Frederick Fragola in this matter. I would like to reserve 3 minutes of my time for rebuttal, Your Honor.
Thank you.
Thank you. When I first started in this profession, my first mentor told me that the perfect case was one where the applicable law would dictate the result that would be reached in the case. And that result would serve the interests of justice and inherent notions of fairness. I submit to you that my client's case fits that definition perfectly. My client, Frederick Fragola, asked this honorable court to uphold the applicable legal precedent relating to defective deeds and prevent Ms. Graham from completely excluding him from the only home he's known for the last 40 years. The law in this case is that legal title to lands and tenements is not transmitted to a grantee by deed unless it's executed, at least substantially in part, pursuant to the requisites of statute. The applicable statute at the time of this particular deed required that a deed conveying any interest in property be executed in accordance with Chapter 5301 of the Ohio Revised Code to create a transfer on death interest in a beneficiary. At that time that the 2006 deed was executed, the applicable statutes required that the acknowledgement be before someone who was able to give the oath, the magistrate or a notary, and to be acknowledged, more significantly, by the grantor in that person's presence. The 2006 transfer on death deed has an acknowledgement clause that is completely blank. It doesn't reference that Ms. Monica Fragola appeared and signed the instrument. It doesn't indicate that it was her free act and deed, and it's not completed by the notary. The notary signs it, but otherwise, again, it is completely blank. The defective deed with a blank acknowledgement clause cannot be effective to revoke a prior deed or to transfer an interest in a transfer on death beneficiary, such as Ms. Graham. This court previously indicated that it is only the execution and recordation of the deed that will create a present interest in the beneficiary. And although the attempted deed was recorded, it was improperly recorded because it shouldn't have been effective having a completely blank acknowledgement clause. The trial court in this case seemed to indicate that the curative effect of 27-1901 could be used to resurrect this deed. But the case law is clear that the curative effect of that statute cannot operate to validate instruments for real property which do not comply with the mandatory requirements relating to execution. And the facts of this case, as this court knows, is that Ms. Fragola, Monica Fragola, first caused a transfer on death deed to be recorded in favor of my client on February 22nd, 2002. That deed met all the requirements of the statute, all the requirements as it relates to execution and otherwise. In October 25th, 2006, a second transfer on death deed was attempted to be recorded, naming Dianne L. Graham as the beneficiary. That deed doesn't say specifically that it's revoking the prior deed, and that is the defective deed that's at issue in this case. After that, on March 1st, 2007, Monica Fragola signed a last will and testament that indicated that all her property would be given to both Mr. Fragola and Ms. Graham 50-50. and then unfortunately Monica Fragola died on January 1st, 2014. But when you look at the Smith-Lessee case and the other binding precedent, it's clear that that 2006 deed could not operate to grant an interest to Ms. Graham, and more importantly, it could not operate to revoke the prior interest of Mr. Fragola. The Supreme Court was quite clear on this matter in the Smith-Lessee case, where it talks about that the defective acknowledgement clause cannot be used to validate such interest. And the court held very specifically that there is no rule of law which will authorize us, the court, to infer that the grantor is just nobody at all. They say it is clear, we regret to say, that no legal estate was conveyed by this defectively executed deed. Ms. Graham argues that any divergence in the case law is a difference between whether the case is more like Smith-Lessee or the Dodd case. If that's the case, then this court must find in favor of my client, because this case is so much more like the Smith-Lessee case. It's a difference between an acknowledgement that is completely blank as to when in the Dodd case where the names were just incorrectly labeled, or there's a middle initial that's missing. It wasn't proper in the first instance in the Smith-Lessee case. And indeed, some of the other courts have mentioned that a close reading of these cases show that the acknowledgement will substantially comply, where in that acknowledgement it in some way identifies the person making the acknowledgement. And that's not the case here. If the acknowledgement clause said, personally appeared the above named grantor, and that she duly executed, I think it'd be a much different scenario and a much different case. But that's not the case that we have here. We have a completely blank acknowledgement. The fact that there are other witnesses further complicates this matter for Ms. Graham's case, because above named, not saying grantor, could mean any of the individuals on this. And for that reason, that deed is defective and it can't be upheld. The Supreme Court went on in later cases and said that the law indisputably establishes the principle that a recorded interest that lacks some requisite of the legal execution, it's not available for any purpose against a third person who may acquire some interest in the property, and actual notice of a prior defectively executed deed doesn't give any value to that. Counsel also talks about distinguishing those cases as those were cases involving mortgages. Well, that's the perfect analogy here, where we have two competing interests to the same property. Ms. Fragola, Ms. Monica Fragola, is not trying to deny that she signed that document because she's not with us anymore. So it's different from those cases where someone might try to dispute the fact that they signed their own mortgage and be enforced between those parties. Again, this is two competing parties who claim to have an interest in that property, and the defective 2006 deed is the linchpin to this. And that's what creates the fact that it could not revoke the prior interest in Mr. Fragola.
What makes
Yes,
this a 2006 deed?
I'm sorry, Your Honor?
There's no date on this deed anywhere indicating what date that Monica Fragola signed this deed. There's no date anywhere on it that says what date it was signed.
That's correct, Your Honor. No, that's absolutely correct. I'm saying 2006 deed because that's the date that it was recorded at the recorder's office. But again, you're correct that we don't know with an absolute certainty of when, in fact, it was signed. Now, since then, the notary came forward and attempted to file an affidavit of facts, which again cannot be used to resurrect a defective deed. But that's the only way we know, because this is an acknowledgement that's completely blank. It's not that it says Ms. Fragola and just omits other things. It's not substantial compliance. It's zero compliance in this case.
Well, it's not even, I mean looking at the deed, even above where Monica Fragola signed the deed, it doesn't indicate what day of the year that she uses. There's nothing on it that indicates any date at all, other than the expiration date, the commission expiration date of the notary, which would have been in the future at some point,
Yes, sir.
and the date that it was recorded. Those are the only dates that are on here.
Yes, and I think that compels a result in our favor. Certainly the other cases are similar in that regard. The Farrell case from the 5th District, and the other cases subsequently from the Ohio Supreme Court. They go on and on at length about how these defective deeds cannot create an interest in the property. In the Rickles case, the 3rd District analyzed when a transfer on death deed would not be valid. In that case, the document did not transfer any interest in the real estate. I think that's persuasive to us, because although that was an issue on timing of when the new statute took effect and when it was recorded, it speaks to the fact that something that's defectively executed in some way or has a defect on the face of the deed cannot be used to complete the transfer. And we'd also talked about in the briefs, again, the trial court, although it doesn't specifically say it's doing it, it tends to put a lot of stock into this affidavit of facts that is filed. And so, in essence, it has done what has been forbidden by the case law, that the affidavit relating to facts is creating an interest in Ms. Graham, and it is reviving something that is defectively executed, long after the death of Ms. Fragola, that is doing so. The trial court also talks about the Nemi case as being somewhat persuasive. I think that case is different because, again, we have someone who's standing in the shoes of the decedent. Again, this is not Monica Fragola or Monica Fragola's representative that's challenging this deed, saying, I was not a party to that deed, when she in fact was, allegedly. This is a case between two competing interests. But even then, I think the dissent of Judge Cannon, who this court is very familiar with, he sits by designation sometimes on this court, a very good judge, he has a very persuasive dissent where he talks about that the purpose of the notary clause is to acknowledge that the person signing the instrument is of sound mind and memory. To your point, Judge Schaefer, that it creates, when the act of signing occurred, that act of signing was their own free act indeed, and that the signature was not made under duress, but it was properly acknowledged. And for that reason, we hope that you find in favor of my client.
Thank you. You may proceed.
Thank you, Your Honor. May it please the court, counsel. I'm Joseph Cajun. I represent the appellee, defendant Dianne Graham. What we have here, generally speaking, is, of course, mom deciding between her two kids as to who gets her house. The issue before this court is how to apply the law on defective acknowledgments to TOD deeds. There's a lot of case law on defective acknowledgments, but specifically whether, in this case, a transfer on death deed is rendered ineffective as against a prior TOD beneficiary where the notary has failed to fill in the acknowledgement and where there's no factual question as to whether the grantor signed in front of the notary and whether there's no subsequent purchaser for value. The rule in this case comes from a long line of cases, not on TOD deeds specifically, but on all kinds of deeds. It does involve the Smith-Lessee case, but the law has evolved a lot since then. The rule generally is a defectively acknowledged deed passes title equally with one acknowledged as against the grantor and her heirs and the grantee and his heirs. But without effectual acknowledgement, a deed cannot be valid against subsequent creditors and purchasers. That comes from our Citizens National Bank versus Dennison. It's well laid out in the Nemi case, the estate of Nemi, that counsel referenced and the trial court relied on. Now, under this rule, we believe that this deed is valid and enforceable as against a prior TOD beneficiary. First, Mr. Fragola's case law all has one thing in common. To get to the result he wants from this case, he needs a subsequent purchaser for value. It starts with the Smith's lessee case in 1844, and it goes on through every single case that comes out the way he wants. What we're protecting is subsequent purchasers for value, and so we'll get into why that's so different.
Well, the trial court itself, so there's just not any case law.
Sure, there is no
So you have
case
to
law
reason by analogy.
specifically on TODs.
So there's nothing wrong with that, is there a reason by analogy? We have to do that all the time.
No longer.
Appeals judges.
Right, and we're going to analogize to both of those cases. Second, a beneficiary under TOD deed has no present interest in property. So his designation can be revoked at any time. Therefore, there's simply not the level of protection and reliance that a subsequent purchaser or a subsequent creditor would have. Third, the cases that involve a defective acknowledgement and not a subsequent purchaser for value, those cases enforce the deed. And we'll get into those. Fourth, the TOD deed naming Dianne Graham, we believe by the virtue of the affidavit, becomes totally enforceable. She executed the deed, it was witnessed, it was notarized, it was recorded, and now we know. I'm sorry?
When did that stuff happen?
2006, Your Honor.
When?
It's in the affidavit, I don't have the
But it's not
affidavit
on
in front of me. It is
Nothing
not
was
on
on
the
the
deed.
deed.
That's correct. That's
Not
correct.
even in the acknowledgement form. I mean, it's nowhere on the deed when the deed was executed.
That's correct.
Doesn't that, you find that troubling?
I do find it troubling, Your Honor, but I think part of the problem with that is, well, for one, we have the case law on what to do in those cases. But number two, at some point we get into, we protect subsequent purchasers for value from those type of problems. But there's no evidence here that Monica didn't sign it. There's been no evidence at the trial court that she didn't intend to sign it, that she, was forced to sign it. And this notary comes back and says, yes, in fact, I witnessed it. It happened in front of me. She didn't just acknowledge it. I actually saw her sign, and it was my fault. I didn't fill it in.
That's assuming that the affidavit, the subsequent affidavit of the notary is permissible.
True, true. At the same time, there could have been evidence in the lower court that notary could have been deposed or, to root out if there was some malfeasance going on with this TOD deed in 2006.
But if by accepting that affidavit, isn't that in fact creating an interest in the property?
Not as to between the deed and the grantor and her heirs. The rule really says you can enforce a defectively acknowledged deed as between the grantor, grantee, and their heirs. And what we find is, because he's not a subsequent purchaser for value, he's not subsequent at all. He's prior. He doesn't have an interest. He didn't purchase, and he exchanged no value.
Well, if the deed were found to be invalid for whatever reason, the property would it not revert back to the estate?
Exactly, Your Honor. That's what we believe, and because of that, that's why the Nemi case becomes so important. Because essentially that's what happens in the Nemi case, is you have an aunt giving a power of attorney to her nephew, then telling her attorney she wants to give her property to her nephew. The nephew takes the deed prepared by the attorney to the bank, signs it POA, but the notary actually puts aunt's name as who appeared before me and signed this deed. So in that case, it's worse than blank. It is decidedly wrong as to who appeared and signed this deed. And in that case, the court in Nemi says, even though it's defectively acknowledged, we're going back on the case law of what to do in those cases. And as between an estate, which is the grantor and their heirs, versus the grantee, we find that an effectively acknowledged deed is valid and enforceable. This case is very similar to that case, and that explains the trial court's reliance on it. It's the closest analogy we have. The Nemi case specifically says, let me find here, that defective acknowledgement can result in an inability to pass legal title in the context of affording notice to creditors and subsequent purchasers. Nevertheless, as between the grantor and grantee, the deed is valid despite a defective acknowledgement. That's the key here, is what we have to do is decide what Frederick Fragola is legally. He's not a subsequent purchaser for value, that much is clear. He's, for the reasons mentioned. What he is a transfer on death beneficiary that's been revoked. And because that TOD doesn't grant any present interest and can be revoked at any time, it's really not different from a right to inherit from someone who's still alive. We don't have a present right to their house. If they sell it or give it away, we have no right to come back against that person, even if there was a defective deed. And essentially that is the Nemi case, is the heirs of Nemi are saying, give us back this house, it's defectively acknowledged. And the judge saying, no, that's not the right answer.
Well, isn't this, in essence, like a will contest, sort of?
Essentially, yes, yes. And what's so interesting about these cases is the subsequent value purchaser for value is the key. It's why do we go out of our way to say that just because a notary making working wages and maybe ill-trained sometimes doesn't fill out 4 lines on a paper, and I believe this one doesn't even have lines, but generally speaking there's lines, just because they don't fill it out, does someone forfeit this property?
Let me ask you a question. It indicates here that the grantor is the one who prepared the document.
Correct.
And evidently she's the one who typed all this stuff in here.
Correct.
And she missed all these spots?
I believe at the top there's a printed line you can almost read that says it came from a form book or something like that.
Yeah, it's a form, but but there's empty spaces where she's filled in a bunch of them, but some of them she just didn't fill in.
I believe that generally when we do one of those, the notary, when it's signed, would fill in the rest.
These are
the
parts,
preparer,
this is above the signature line.
right, the preparer would fill out the grantor's name, the legal description, and those things as she did, and then when signed, the notary would have to fill out who appeared and on what date. And so, to that extent, it is the notary's fault, if you will, that this didn't get done.
In the acknowledgement clause.
In the acknowledgement clause.
But not in the body of the deed.
Correct. So we would say the reason we protect subsequent purchasers for value, and by the way, the Smiths case had 2 subsequent purchasers for value, and those people won. Those people are actually out money. They've paid for a property that someone else is now saying they own. Smith's lessee was the owner grants a mortgage with a defective acknowledgement. Then he sells the property. And then that guy sells the property again. And it's the mortgager trying to come against this new purchaser and take the property back. And so Smith's lessee says, if they rule in favor of this mortgage, this guy who's bought the property 2 lines down the road would now lose his money and the property. And that creates a very unfair result. So throughout our legal basis, we're protecting, and the cases play this out, we're protecting subsequent purchasers for value because they're the ones who've relied on previous deeds. They're the ones who've paid money in that reliance and now would be out of property. The law abhors a forfeiture, so we avoid that result. But in these cases where we have a grantor versus a grantee, or someone's effectively standing in their shoes, we find in favor of the grantee. It's not fair to give the property back to the grantor or someone else who should get it from them as an heir, when all that happened is a notary didn't fill in some blanks. That doesn't make enough sense. There's not enough.
I have to ask you, it seems like you're just saying the notary's almost superfluous. Why even have it notarized then? if we can just come in later and have, somebody, why even sign it if she can just come in, or he can come in later and say, oh, this is what happened, or why didn't it happen at all?
Well, Your Honor, I would disagree. I would say, in this case in particular, it's witnessed by 2 witnesses and stamped and signed by a notary. So the notary does know her job, I assume, and does check to make sure it's the person she says it is. And, when they sign, they acknowledge those things.
But she doesn't really swear to any of that. I mean, she doesn't fill in the blanks, so really, what is it?
Well, it's fair, Your Honor. The purpose, I would say, at that point is we have the stamp. We know what that means. We know that that should mean, anyway, that this person really did appear before me as who they said they were, and we signed when they signed. The stamp alone should say that much.
What do we make of the subsequent will and the fact that that seems inconsistent with, well, I'm not sure which party it's inconsistent with, maybe both. The fact that the decedent indicated that she wanted to divide her property between the 2 heirs.
Your Honor, I think it's very typical to have that in a transfer on death situation. Of course, now we have transfer on death designations since I've been practicing, but even when I do see TOD deeds coming back or joint survivor property, usually in the will it will say that as part of that residuary clause, I'm giving all my property, real and personal and otherwise, to these people. And it's more of a dragnet clause, in my opinion, in this will, that we know that certain things are going to be non-probate property and won't pass by the will. And this is one. But we're always putting that in the residuary clause, always putting that real property language, even if at the time we create those documents, all the real property or even all the personal property will be transferred on death or payable on death. So to me, the residuary is just a dragnet. I don't think we can look into that as intent of what she actually wanted with a specific parcel of real property in the absence of a reference to a specific parcel, which this will does not have. As to the cases that there's really no case that finds that a defective acknowledgement and the affidavit. That's a piece of new information that we really haven't dealt with. But, and for the purposes of my argument today, I've largely assumed that it is defective. Because I think if it is defective, I think the case law still favors, as between these parties, my client. But what Smith's lessee and those cases don't have is really the other information. They don't have the other witness. They don't have an affidavit later saying, oops, I failed to fill in the blanks. And so this case has an extra level of protection, if you will, an extra level of fact that can give us some confidence. But like I said, even if we don't win that argument, I think we still win as between these parties. I think the key would be if Frederick had somehow managed to sell this property before this case was heard, we would have a subsequent purchaser for value. And perhaps that person would defeat my client because they would be out.
And you're out of time.
Thank you, Your Honor.
Thank you. You have a little less than 3 minutes remaining.
Thank you, Your Honor.
Thank you.
Nowhere in the Smith lessee case does it say that the rule of law is limited to subsequent purchasers for value. They even say, we regret to say. They use that language, meaning this is the result we're coming from. We're not looking at the equities involved. This is the rule of law that must be followed. This is a case, again, of competing interests. No estate was opened in this matter. The estate of Monica Fragola is not trying to invalidate this deed. 2 people who are claiming to have an interest in the property either by the prior transfer on death deed to my client solely, or the fact that it should be divided 50-50 between the 2 heirs if the subsequent deed revokes the prior designation but does not create a new designation. In the Campbell case, cited in the briefs from the 6th District, that related to a power of attorney. So again, the Smith lessee case didn't limit this to one particular type of documents. It was a rule of law relating to deeds, which is what this is, a transfer on death deed. And again, the Supreme Court, even later, 1901, talked about actual notice of the prior defectively executed deed doesn't impart any value. Again, saying that this is not a rule limited to subsequent purchases for value. This is a rule of law relating to deeds and the consequences thereof. Judge Moore, you had referenced what this court is to make of the subsequent will. One thought is that it appears perhaps that Ms. Fragola thought that she was giving both of them, in accordance with the terms of her will, one half of the property, that she wasn't revoking the prior transfer on death deed to my client, but she was just allowing the vehicle for the property to go in accordance with the terms of her will to both parties 50-50 without having a case opened and probate. But the law is clear. The equities, again, are on our side. This is a case where Mr. Fragola has lived in this property for the past 40 years. And he was completely blindsided by the death of his mother to find out that he somehow loses all right and interest into this home that he's been at. And for that reason, we ask that this court uphold the applicable precedent and reverse the decision of the trial court and remand for further proceedings.
Thank you. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as we will also release our opinion and place it on our website. Thank you.
Okay, thank you, Your Honor.